All set over there? Okay, please proceed.
Good morning, Your Honors. May it please the Court. I'd like to reserve 5 minutes for rebuttal.
Keep your eye on the clock, okay?
Will do, Your Honor. This case arises from ICANN's intentional decision to disregard the application and auction processes set out in the applicant guidebook, which it admits are in place to protect the public interest in allocating critical internet resources. The issues I'd like to address today, subject of course to the Court's questions, are one, the fact that the contract at issue implicates the public interest, and as such any exculpatory clauses contained therein are void. Second, the fact that Section 1668 of the California Civil Code bars exculpatory clauses which seek to prospectively exculpate ICANN from fraud, wrongful conduct, and intentional or negligent violations of the law, which my client submits were alleged in the operative complaint, and that to the extent the Court determines they were not sufficiently alleged, certainly leave to amend would have been appropriate. And ultimately that regardless of the Court's determination on Section 1668 applicability and the public interest nature of the contract at issue, that the clauses are unconscionable, meet both procedural and substantive unconscionability issues, and as such that provides another basis for remanding this case to the
Counsel, I would just want to clarify one thing. Are the issues in this case all issues of state law, California law?
They are, Your Honor. Yes. And so to begin.
One other question before you begin. As I understand it, you didn't argue below that the covenant not to sue doesn't apply to claims against ICANN. Are we to treat this on appeal for the first time?
Yes, Your Honor. This Court is allowed to reach that issue de novo.
Or we can treat it as having been waived, right?
Your Honor, I would submit that the first...
I know you don't want that, but I'm just saying that's where we are, right?
Yes, but I would submit that the facts at issue would allow this Court to, in fact, reach the issue today, and that would be the proper outcome. Beginning with...
So getting back to your statement that this is really an exculpatory clause, why isn't it a valid covenant not to sue, in that there's an option to go to arbitration? As I understand it, originally your client opted to have that option, but then withdrew that in favor of litigation. So the fact that there was essentially a mechanism under the release to challenge ICANN's decision-making process, doesn't that make this then a valid covenant not to sue?
Your Honor, no. And the main reason is that although the provision includes these accountability mechanisms, one of which is independent review process, which has been described as an arbitration, it's not actually a binding arbitration. Despite indications in ICANN's bylaws and certainly what applicants for the new GTLD program were like to believe, in that the arbitration provisions were meant to be final and precedential, ICANN has repeatedly taken the position since the applicant guidebook and since applicants paid to participate in this process, that in fact the decisions that are issued by the independent review process, the IRP, are simply advisory and they're non-binding. And in fact, at least one IRP panel has taken issue with that, and that is the IRP panel in the .Connect Africa case that's cited in the briefing.
Is there anything in the record that shows that IRP decisions are advisory only?
Yes, Your Honor. I would direct you to the excerpt of record. Bear with me for one moment. There's a decision in the record from the independent, from the IRP and the panel that issued a decision in that regard that specifically notes and quotes from ICANN's position that these decisions are non-binding.
And where is that in the record?
That would be ER 109. And in fact, the ICDR ruling stated, it explained why it believed that actually these processes should be binding, and noted the fact that ICANN owed a duty to the applicants to the extent they were going to take the position that these so-called arbitrations were in fact non-binding and advisory opinions only, that they had the obligation to not only advise the applicants of this fact prior to the submission of these applications in the exchange of a $185,000 fee, but also that this was something the Senate may wanted to have known during the time when ICANN was seeking to be privatized. And it was noted that the IRP process touted by ICANN as the ultimate guarantor of accountability is now nothing more than an advisory process.
I'm troubled by what you're saying here, because as I read the document, I see nothing in there about it being advisory. Apparently this panel was a one-off kind of a thing. Are there more cases where the IRP panel says that this is only advisory?
And Your Honor, my understanding is that ICANN has taken the position.
No, I don't care about that. I'm asking you, where in the document, because we're bound by the document here, where in the document does it say that the IRP decisions, which are effectively an arbitration, are, and they're composed of an independent panel of arbitrators, that those are advisory only?
The documents, in fact, say that these would have final and precedential value. Unfortunately, that's not the case in practice.
So is the remedy then to basically treat this as an exculpatory clause because ICANN has taken a position that's contrary to its bylaws, or is the remedy in some other forum to say, look, comply with your bylaws and treat these arbitration decisions as binding?
Well,
It seems to me to be the latter, right? In interpreting whether there's an alternative mechanism here, we're going with the bylaws.
certainly, it would seem to me that the path of least resistance for ICANN would be to simply comply with what it said from the get-go, which is these IRPs are going to be final and precedential value. To the extent the court wants to take this opportunity to provide guidance to ICANN in that regard, it would seem like a good thing. That said, we do have now at least one California state court decision which has determined that, as stated, these clauses do not cover claims for fraud, wrongful conduct, and in fact, recently even decided, and excuse me, it was about a year ago now, that to the extent the plaintiff in that case had presented facts that suggested ICANN had in fact violated in a fraudulent, intentional, and wrongful manner certain of the bylaws and sections of the applicant guidebook, that there was a triable issue of fact, and the case would need to proceed beyond
Is this a
summary
case
judgment.
that you've cited to the court?
This is the Connect Africa case, and it is cited in the reply brief of the most recent decision.
So your perspective is that this is just a big fraud.
By this, Your Honor,
Meaning the claims you make that ICANN has treated your client in a fraudulent manner, that the written documents really don't mean anything, they're just joking.
Unfortunately, that's how the situation has played out.
Are you claiming what happened here was intentional misconduct?
Yes,
in
Your
terms
Honor.
of your client not getting this?
Your Honor, the intentional misconduct is not that my client did not secure what it wanted out of the auction. The intentional misconduct is that ICANN threw away the applicant guidebook in determining that it would push forward with attempting to delegate a GTLD to an entity who has been demonstrated to have violated the terms of the guidebook.
And who's that, the IRP?
No, that is one of the other applicants, NDC, who has admittedly assigned the rights of its application, which is a potentially disqualifying act under the applicant guidebooks, to a third party, VeriSign, who did not participate.
I'm sorry, I'm a little confused. So what is the intentional misconduct of ICANN?
the intentional misconduct of ICANN is that when the potentially disqualifying conduct was brought to their attention, that they either intentionally refused to investigate in order to benefit themselves and the third party ICANN, that they were aware of this agreement behind the scenes and decided not to act.
Did this have anything to do with your client?
It impacted.
Well, I understand it, but you're saying that ICANN dealt with another party, a third party, and that they dealt with them in an improper manner. Indeed, you're alleging intentional misconduct. What does that have to do with this case?
The intentional misconduct is actually with regard to the conduct of the auction process to delegate the GTLD. And so.
Did that happen in this case?
Correct, yes.
They delegated the auction in this case?
The auction took place. The winning applicant, it has come to pass, did in fact have an agreement to assign their rights in the application to a third party. And
that's illegal from your perspective.
Correct. It violates the guidebook. It violates ICANN's obligations of open transparency. It violates their obligation to ensure that all of the
But
parties.
why isn't it appropriate to then take up all of these issues, the various ways in which they violate their own bylaws or guidebooks, in the arbitration forum that's been provided in the bylaws?
Our argument would be, one, that the claims at issue do not fall within the clauses that are set forth within the applicant guidebook, and in fact, I believe the district court determined that it's not clear to the district court that these allegations and these claims would fall within those clauses, but also because to the extent that ICANN has taken the position that these arbitration processes are non-binding, the parties will just end up potentially right back in the same spot, potentially having blown statute of limitations.
Are those allegations of complaint that ICANN basically is now acting contrary to the mandatory nature of these arbitration proceedings? Is
that allegation is not in the complaint.
Right. So I think that that's the point, right? You're invoking California Civil Code Section 1668 in order to invalidate what appears to be a covenant not to sue on some fraudulent theory, but that theory, as the district court pointed out, isn't really based on fraud. So when you look at the allegations, the complaint, they all relate to ICANN's handling of the application and running the auction and how they respond in terms of the investigation to the irregularity and all that. That all of those claims alleged in the complaint seem to me to be covered under the umbrella of the covenant not to sue. So how do we deal with that? The fact that now some of the arguments concerning fraud appear outside of the face of the pleading.
And I would ask the court to consider, one, that this is not a situation where the complaint was filed 2 years after the conduct at issue. The complaint and the amended complaint were filed during a fluid situation where facts were coming out at a quick pace. This is also not a case where my client was provided with multiple opportunities to amend or the early third-party discovery that it sought. So certainly, at the very least, I would request and believe my client can plead claims that would fall outside the scope of Section 1668 to the extent the case is remanded with leave to amend.
Okay, counsel, you've gone over your 3 minutes. We'll give you a little bit of extra time, but let's hear from the opposing counsel, okay?
Thank you, Your Honor.